employer's obligation: take timely and effective action to prevent harassment, conduct immediate, impartial, and thorough investigation. So what does that involve? And it could be a whole nother seminar on how to conduct an investigation. It involves receipt of the concern, and then you go through the whole process as in any normal investigation. You talk to the person who's complaining and say, okay, what happened? When did it happen? Why did it happen? Do you have any idea? Has it happened in the past? Do you have any documents to support this? Were there any cards sent to you, emails, text messages? Go through the whole process conducting a thorough investigation. And it needs to be an impartial investigation. It needs to be thorough. And at that point, you need to make a determination. You need to put your best foot forward as an HR person or as a business owner. Who do I believe here? It's really a credibility determination. Do I believe the witness or do I believe the accused? And go through the list, write up a report, an official report at the end, and say, hey, this is where I'm falling on this. I've interviewed all these witnesses on both sides, and I'm making a determination here that maybe harassment did occur. And because of that, we're going to have to take disciplinary action. And that disciplinary action could involve termination if it's severe, suspension, or transfer. So if you have a large workplace, maybe it involves moving the accused from one part of the warehouse to the other part of the warehouse, something along those lines. And it's important to remember that in situations like this, when you're conducting an investigation, it's okay to be wrong. I mean, this isn't a criminal court of law, so you don't have to show that every time that under the circumstances, your investigation revealed information that made it look like they're guilty, beyond a reasonable doubt. You are an HR person, you're not a judge. You do a thorough investigation, you document what you have, and then under the circumstances, you make a decision. You put your best foot forward. As an employer, you are not going to be liable if you make the wrong decision. So if you have a situation where there's harassment between two individuals, you find that the harassment occurred and you terminate the individual who is a harasser. There's no cause of action for wrongful discharge in PA for something like that. So if I'm the accused harasser, I can't then bring a claim against you as the employer saying that I was wrongfully discharged. And I think I mentioned this briefly before. There's no report of harassment by employee. There's no liability. I mean, you're not the Psychic Friends Network. You're not going to be able to just read people's mind. You often have employees, and maybe in some cases rightfully so, that are hesitant to report issues, and they're afraid to report because the supervisor will terminate them or take other adverse action. So people don't want to bring these things to your attention. Again, this is where your policy and your communication and your training come into play. You need to advise folks that here's our retaliation or anti-retaliation policy. Anyone who retaliates against someone who brings a legitimate good faith complaint is going to suffer the consequences. They as well are going to be subject to discipline and termination. And so here's where it's also important to train not just your employees, but your supervisors. I mean, you have to communicate to your supervisors clearly, hey, if someone comes to you with a claim of harassment or some other form of discrimination, it's part of your job duty to come to us and tell us. Come to HR, come to management. Because if you don't, and this whole thing blows up, and there's a situation where you knew about this and didn't communicate it to us, guess what? You're fired. Because that is part of your obligation as a supervisor to protect the company from liability and from damages. There's no supervisory liability under federal law. However, there's potential individual liability under the Pennsylvania Human Relations Act. So you could have supervisors who could be individually sued, could be subject to damages just like the company pursuant to the PHRA. And that's something else that you need to communicate to your supervisors. Essentially scare them straight, saying, listen, if you're not on board with how we're handling things here, guess what? You should be aware that you could be sued individually. And these type of lawsuits aren't insignificant. And if it's someone who's really gone rogue, you as an employer could say, listen, you know what? we're not even going to defend you. You're going to have to get your own counsel. You know, guess how much that's going to cost. So you need to understand as part of your position that take these things seriously, pass them along to the folks who know how to handle them.